Chancellor of Lloyd and Google LLC.
Good morning. My lady and my lords, in this matter I appear for the appellant along with Mr Campbell and Ms Wakefield. Mr White and Mr Craven appear for the respondent. As the court knows, this is an appeal against the decision of Mr Justice Warby on the 8th of October of last year, whereby he refused the claimant permission to serve a representative action on the defendant out of the jurisdiction. Permission to appeal to this court was granted by Justice Lewison on the 21st of January. The claim is under the Data Protection Act 1998 and arises from what we say is the clandestine tracking and collation by Google of information relating to iPhone users' internet usage on the Apple Safari internet browser in the course of 2011 and 2012. Something which is generally known as the Safari Workaround. And my lady may have a long time ago a very faint recollection of this.
A very clear recollection.
Better than mine, really, of that case where it came before this court in the case of Vidal Hall and Google. This case upheld the judge's order for service out of the jurisdiction in that case. The court may know that the Supreme Court granted permission to appeal, but the matter was subsequently settled, so no appeal was heard by that court. The claimant sues as a representative under CPR 19.6 of a class of persons who we say have the same interest in the claim, namely approximately 4.4 million iPhone users who use the Safari browser during the relevant period. The court will have seen the chronology of Core Bundle 4. I'm not going to that. I hope that's clear. The judge held that neither the claimant nor those who we represented had suffered damage within the meaning of Section 13 of the Data Protection Act. That further, that the members of the class didn't have the same interest for the purposes of CPR 19.6, and it was impossible to ascertain the membership of the class, and that in any event he would have refused permission as a matter of discretion. And the claimant says that the judge was wrong on all three grounds. The claimant's case is, put shortly, that a combination of data protection law and the long-established representative action procedure can provide an effective remedy for mass breaches of data protection rights, where in practice, as the judge recognised, neither individual claims nor a group litigation order are practically viable. Google's case was in substance that whether or not its actions were illegal, the law should be interpreted in such a way that individuals should have no remedy in law. My lady and my lords, we say that the judge took too restrictive a view of the right to compensation for breaches of the fundamental right for the protection of personal data, and too narrow a view of the representative action procedure. The court may recollect the words of Lord Lindley in 1901 in the Taff Vale case, where, speaking of the representative action procedure, he said that the principle on which the rule is based forbids its restrictions to cases for which an exact precedent can be found in the reports. The principle is applicable to new cases as to old, and ought to be applied to the exigencies of modern life as the occasion requires. Modern life in 1901 concerned difficult questions as to the liability of trade unions for damage caused by strikes. Modern life in 2019 particularly concerns the activities of technology companies and data breaches. And we say that the law is sufficiently flexible to provide a remedy in the modern situation. My lady and my lords, the background is, the factual background is uncontroversial. I don't propose, unless the court wishes me to say anything more about it. It's to be found in paragraph 6 to 30 of the judgment. And similarly, with one possible exception, the principles relating to service out of the jurisdiction are also uncontroversial. It's set out in our skeleton, but there's, save for the question of the test as to on serious issue to be tried, there doesn't seem to be any dispute between the parties. So what I propose to do, subject to the court's view, is to begin by dealing with the first ground of appeal, which is the judge's holdings on damage,
Yes.
which is obviously central to the case. That involves consideration of the way in which the English law provides compensation for the breach of the fundamental right to data protection. That, as the court knows, and I don't think it's necessary to turn it up, is a right protected by Article 8 of the EU Charter, a right which certainly at the moment is one which the courts have to apply where EU law is engaged. The position may of course be different after Halloween. The claimant's position, as the court knows, is that the court has power to make a single reward of damages to each class member for what we've called interference with or loss of control over their personal data, to compensate them for the loss of control over their personal data as a result of the operation of the Safari Workaround by Google. This is not a conventional award. It's not a tariff. In the end, we say that the court will arrive at the sum by looking at the nature and quality of the infringement, looking at matters such as what Google knew, to what extent it was deliberate, to the nature and extent of the profits made by Google out of the operation of the Safari Workaround. All those are matter of factual assessment, which in the end will have to be made by the trial judge. We don't say, oh, in all such cases it should be £50 or £750 or whatever the figure is. It depends on the court's assessment in the end.
Mr. Tomlinson, you can't elide the profits made by Google with the loss suffered by your class, can you? I mean, you can't just airily say we're going to look at the profits made by Google and find a tariff award. I mean, either you're looking at damages for loss suffered by the claimant, or you're looking at root and part damages, sorry, as I would call them, or one step.
I would call them that as well. I think the Supreme Court make us say something else. But my Lord, the reason I say that is because I'm not eliding the two. That one must look at the nature and quality. We say we must look at the nature and quality of the breach. So some, and I accept this, and it's an important point, that some breaches of data protection rights are trivial and de minimis and don't sound in any damages. But how important the breach is a matter which is relevant to the assessment of damages in the way that the loss of control damages that we say should be assessed. For example, if the ICO, I of course accept this is a slightly different area, but if the ICO is assessing what penalty to impose on a data controller for breach of the data protection principles, what the ICO does is, among other things, look at the whether and to what extent the breach was deliberate, and whether and to what extent the data controller has made a profit out of the breach.
Would you be looking potentially to claim for exemplary or punitive damages?
My Lord, no. It's
not needed, but
no. This isn't a. This isn't a case where we would seek to bring ourselves under the second limb of Brooks and Barnard. But it's not, and I'll come on to this in a few minutes, but it's not, neither is it vindicatory damages in the sense condemned by the Supreme Court in the Lumber case.
Well, what sort of damages are you claiming?
Well, Well, look, these are compensatory damages. They're compensation for, in one sense, non-material damage, as is referred to in the European authorities, and non-material damage in the sense of loss of control or interference with your personal data rights.
Why isn't that vindicatory?
Well, can I answer that?
That's practical commentary.
Well, can I answer that question in a moment by because what I want to do now is to just say something. I'm going to go into it in more detail in a few minutes, but about the Gulati case, because this is we say that central to this appeal is the fact that on analysis you can't draw any analytical distinction between the approach to compensation for breaches of Article 8 and breaches of data protection rights. They're covering exactly the same area, and the same principles apply, and indeed this court in Vidal Hall, I'll come on to it in a moment, said as much. And we're dealing here with the same kind of damages which were awarded by the judge in Gulati and were upheld by this court.
Well, you're not. I mean, the damages in Gulati were for the tort of breach of privacy. This is a breach of the Data Protection Act.
Well, it's the tort is I think properly speaking, it's not properly so called. The tort is breach of statutory duty. But
breach of statutory duty, but in the context of infringement of rights of privacy.
That's what. Yes, exactly so. Exactly so. And as is this court some years ago described the tort of misuse of private information as using these words: the very content of the tort is Article 8 and Article 10. Where although true it is that in Vidal Hall it was accepted that misuse of private information was a tort for the purposes of analysing the principles relating to service out. It's a tort whose content is the fundamental right. It's a very curious creature, I think everyone accepts. And breach of statutory duty under the Data Protection Act is a tort whose very content is breach of the fundamental right. So they're creatures that they're not the same creature, but they're very, very close cousins.
So you say Gulati and DPA rights and damages are very closely related.
Yes, and indeed, and I hope to demonstrate that they must be approached in the same way. The criticism was made. I want to come back to Gulati in a bit more detail, but I can just give the references now. The criticism was made by counsel for the defendant in Gulati, but what was being sought were vindicatory damages, and that was expressly rejected by Mr. Justice Mann at first instance at paragraph 132, and by this court at paragraph 48. And they were damages of precisely the same type that we say should be awarded in this case, namely damages which are not to compensate for distress, but to compensate for the infringement of the right itself. The judge began with, as this court will have seen, he began with what he describes as a simple question of statutory construction, section 13.1 of the Data Protection Act. It's perhaps just a good idea to turn it up because it's in Authorities Bundle 1, Tab 1. Unfortunately, the pages aren't numbered, but
What paragraph in the judgment?
13.1 is the material paragraph because 13.2 was I was going to say struck out, but construed out by this court in Middle Hall. So 13.1 is the material paragraph, and what the judge says is material subsection. An individual who suffers damage by reason of any contravention by data controller of any requirements of this Act is entitled to compensation of the data controller for that damage. He says, well, that must mean that the damage and the infringement are two different things, connected by a causal link. And we say that that approach actually is contrary to the whole scheme of the data protection legislation and also to authority.
So where did you say that?
No,
55.
Oh, I see.
it's just collapsed. And essentially we say that, for the reason I've just already mentioned, that the approach to damages under the Data Protection Act has got to be consistent.
Do you want to take a moment just to reconstruct the bundle before?
Mr. Campbell.
I think we're on paragraph 55.
Yes. So that the judge says this is a matter of statutory construction, and that damage and the infringement must be two separate things.
You say that's contrary to authority.
We say that doesn't recognise the need for a consistency in approach between damages under Article 8 and damages under data protection legislation.
But your approach, in effect, requires section 13.1 to be read as though it says an individual is entitled to compensation from a data controller in respect of any contravention by that data controller of any other requirements of the Act. So that was what was intended. Why didn't it say that?
Well, I'm going to come on to this, but put shortly, it's important to bear in mind that Section 13, unlike the rest of Part 2 of the Act, is directed, covers compensation not just for data subjects, but also for any individual. So all the other rights in this part of the Act are conferred on data subjects, subject access requests, rights to object, and so on and so forth. But here, compensation is, the right is wider, so any person, an individual who suffers damage is entitled to compensation, whether or not they're a data subject.
But that hardly answers my Lord's question. I mean, what he says is, puts to you, is that it would have been very easy to draft a section that didn't include a causative requirement, but this one does.
Well,
So how do you get round it?
well, it would have been easy. This, in fact, reflects, as the judge and Mr. White point out, the requirements of this almost mirrors exactly the wording of the directive itself. But it could have been drafted in that way, but it wasn't. But does the fact it's drafted in that way preclude the argument I'm advancing? And my Lord, I say...
Yes, do you accept that on the way it's drafted, it leads to the, just looking at the pure question of construction on the words used in section 13.1, would lead to the conclusion that the judge drew, if one looked at that in isolation? I understand your point is a wider one.
Well, Malady, I do. if damage is understood as being in all cases a different thing from the infringement. But if we say an individual can, a data subject can suffer damage by reason of a non-trivial infringement of the requirements of the Act.
Sorry, can you say that again? I don't think I understood that.
A data subject suffers damage, non-material damage, that is loss of control, damage, infringement of rights, by reason of a non-trivial infringement of their data protection rights.
How do you decide what is or is not non-trivial?
Well, there's a threshold of, it's accepted, I think it's generally accepted, there's a threshold of triviality when it comes to compensation for data protection rights. There's a threshold of seriousness when it comes to interference with
Indeed, so
articulation
surely
rights.
then you have to look at the facts of each particular case to
Yes.
decide whether or not it's trivial.
Yes, exactly so. I entirely accept that. And what we say is that the mass contravention, we say, of the requirements of the Data Protection Act constituted by the Safari Workaround are a non-trivial infringement of data protection rights. And I think in the end is a fact-sensitive matter.
Well, for this purpose, you say at least arguably.
Yes.
But I still haven't really got an answer to the causation question, my lord and my lady, I think now put to you. That this says causation, and you say, well, a data subject suffers damage by reason of a non-trivial infringement of their data protection rights. But that's not an answer to the causation question.
Well, it's not. It says by reason of.
So you accept that there must be causation, but say that there is.
Well, the words by reason of mean as a result of. I mean, I'm not sure I put it as causation, but perhaps that's just a difference in phraseology. But as a result of a non-trivial infringement of the requirements of the Act, a data subject suffers an infringement of their rights which is worthy of compensation.
That was what the judge called circular reasoning, I think. You say he was wrong about that.
Yes, well, it's not, and it's this, well, maybe can I want to develop this point in the context of the, looking at the Galati case, because if I'm right, that the position under the tort of misuse of private information is the same as the position, or very closely analogous to the position under the data protection legislation, and if the position is that an infringement of an Article 8 right is compensable as such, in other words, without demonstrating any additional damage,
Subject to the question of triviality.
subject to the question of triviality, then the same argument must apply in relation to infringement of data protection rights. We've accepted throughout, and although Google suggests this is somehow undermines our case, it's not correct. We've accepted throughout that there are some breaches which will be so minor and trivial which won't attract any compensation. Described in the TLT case as the de minimis threshold.
Just sorry, my thoughts. Just unclear. Are you arguing for one breach, or are you arguing for 4 million breaches?
There's 4 million breaches because in relation to every the rights are individual rights. Each data subject, each member of the class has rights under the data protection under the Data Protection Act in the relevant time.
Well, this may bear more on the second point, the representative point, but if there are 4 million breaches, then you do have to look at the facts of each individual case, each one of the 4 million, on the face of it, to see whether it's trivial or non-trivial.
Well, we don't accept that for the reason that the breach is constituted by the way that Google conducted itself. It was Google is under certain obligations as a data controller laid down by the Data Protection Act. The quality of the breach depends on the nature of Google's conduct. It doesn't depend on any given individual.
But that's not the point that's being made. The point that's being made is, in order in each case to see if there is damage that can be compensated, you have to look at the circumstances of each individual person who has been the victim of the breach.
Well, if the damage for which compensation was sought was distress, of course, you'd have to look at the distress suffered by or not suffered by each individual. If the damage is the very interference with the right, as we say it is, then we say that's the same across the entire class, because the right to have your data processed lawfully in accordance with the requirements of the Data Protection Act is the same right for all data subjects against this data controller. And look, if this data controller has breached that right, it's the same breach for all 4.4 million individuals. One doesn't have to look at them one by one to see what the quality of the breach is. Assume for the moment that we're right about the way that we put the case against Google, and this is something that they did knowing or reckless as to what they were doing. So if there's some element of deliberateness or deliberate desire to make profit out of this breach, that makes it a serious breach, we would say, and that is the same across all. The entire membership of the class, all users are affected in the same way in that sense. And the fact that the judge was impressed by the argument that, well, some people don't really care. So some people think, well, so I'm being targeted in this kind of way, it doesn't matter. Some people would have hardly used the internet and so on. But we say that that's not relevant. What's relevant is what Google did wrong. Perhaps it's
It
just
does seem to me, Mr. Tomlinson, if I may say so, that you are eliding now the infringement that gives rise to a right to damages and the damages themselves. And I mean, I fully understand the difference between loss and damage, but I don't see how you can you can reason from saying that there was a bad breach, which some people may not have cared about, but they nonetheless suffered loss, without saying that there is a conventional award that the law applies to every person who suffers this kind of breach.
Well, that was exactly the argument that was advanced by the defendants in Collating that was rejected by the judge in this court.
For the different tort. But you
Well,
say, I mean, this is seems to me at the moment the crux of your argument. You say it is the same because it's based on Article 8.
Well, I don't say it's the same. That obviously
Similar.
wouldn't be right because Article 8 is confusingly Article 8 of the Charter is about data protection rights, and Article 7 of the Charter is the equivalent of the Convention Article 8. But so the two are not identical. But dealing here with fundamental rights, and as this court said in Collating, there's no basis for treating the two differently. Can I? It may. I don't know if the court's had the opportunity to look at the draft particulars of claim, but the obviously we're at a very early stage. They haven't even been served in final form, but it's tab 8 of the core bundle. And our damages claim is in paragraph 39, page 118. And paragraph 41, we plead that the matters we rely on as constituting the serious nature of the breach. And then something I'll come on to later, paragraph 42 is the alternative, what Sir Geoffrey Voss and I call root and part damages, but the Supreme Court calls something different.
Negotiating damages.
Negotiating damages. It's like the damages that they're doing the negotiating. But anyway.
As far as I'm concerned, carry on calling them root and part damages.
Lord Reed points out what a misconceived view we all have of that. It's probably a good idea for me to go to Collating because I keep referring to it, and it's central to our argument in this case.
Just one, I think it's a minor point, Mr. Johnson, but paragraph 41b, the particulars of claim, there's been no argument or suggestion that these public statements in some way formed part of a contract.
No.
That's not.
No, there's not a breach of contract.
No, it's the statutory tort.
Yes, it is.
Okay.
So, Collating at first instance is at tab 34 of the authorities bundle, which is bundle 2. A very long and comprehensive judgment. The court may be familiar with this was essentially an assessment of damages for misuse of private information in relation to phone hacking, where Mr. Justice Mann, having taken over from Sir Geoffrey Voss as the managing judge of this litigation, was required to assess damages in claims against mirror-proof newspapers. And one of the arguments advanced by the claimants was that one head of damages should be damages for loss of control over the private information, or for the infringement itself, not just for, in other words, in addition to the distress, there should be an additional head of damages. Now, Lady my Lords, the relevant passage begins at page 108, paragraph 108, page 342 of the report. Where, in the first few sentences, the judge summarises the issue between the parties, the heart of the difference, the question of what the claimants can and should be compensated for. In the case of the claimants, compensation shows several elements. Compensation for loss of privacy or autonomy resulting from hacking or blagging that went on, and then compensation for injuries or feelings. And the issue everybody accepted, there was common ground that there was going to be damages for distress, but the question was whether, in addition, there should be damages for the infringement of the right itself, which is the basis for the claim that we're making in this case. Now, there are long passages. I'm not going to read them all out. But
so the element that you're talking about is the third line of 108, compensation for loss
Yes.
of privacy or autonomy
yes,
resulting from the hacking or blagging that went on.
yes. Taking it up at 113, the judge says that in my view a regime which damages were confined to damages for distress would render the rights to a degree illusory, to use the words used by the ECHR, and would to a degree fail to provide an effective remedy. And then he refers to two cases, paragraph 114 and up through to 170, two well-known privacy cases which involve the interference of privacy rights of children. And he points out that in the AAA case, that the one-year-old child obviously was unaware of the interference and couldn't have suffered distress, no question of other damages, and yet was awarded £15,000. In the Weller case, one of the children was old enough to understand, but two of them were aged 10 months, and again an award of damages was made. It's important, perhaps just to note at this stage, that the Weller case was a case, it's true it is that the AAA case was framed exclusively in misuse of private information, but the Weller case was a case which was framed in both under the Data Protection Act and in misuse of private information.
The DPA claim wasn't pursued.
Well,
maybe I was in Weller, the DPA claim wasn't pursued.
well, Mr. White says that, but that's not what the judgment says. If I can, perhaps it's just worth referring to it now. Give it up, pull it up. It's at tab 31.
Went to the Court of Appeal, didn't it?
He did, but not on that. Not on, the issue of damages wasn't examined at the court.
Which tab?
It's at tab 31, so just back in this bundle. So at paragraph 184, Mr. Justice Dingleman says,
Sorry, can you just...
I'm so sorry.
It's just 2 seconds.
So it's authorities bundle 2,
Yeah,
tab 31.
yes, I've got it, thank you.
Perhaps it's just worth looking at the headline. Claimant's children are a well-known pop musician, photographs taken of them in streets in a cafe when they were on a shopping trip, published by the defendant in Mail and Mark. Acting by the father, they brought proceedings for damages, injunction, misuse of private information, compensation under section 13 of the DPA. And then just going to the holding 7. The first claimant was awarded 5,000 compensation damages for misuse of private information and breach of the DPA. And that's supported by, if one looks at 184.
I'm sorry, I've made a mistake. It wasn't the subject of a separate argument, but it does appear to have been run in parallel, and I apologise for that.
Sorry. Which paragraph?
184.
Yes.
common ground a claim for infringement of the Data Protection Act stands or falls on the claim for wrongful misuse of private information. In light of my findings above, I found the claim for breach of the Data Protection Act to establish. And then it's right that there's not a separate analysis of the Data Protection Act damages position, but at paragraph 200, Mr. Justice Dignan says, for the reasons given above, I found there was a misuse of private information in the publication and so on. There was also a breach of the Data Protection Act.
Yeah, well, that's not terribly helpful, is it, as a matter of analysis?
Well, look, maybe it isn't, and I, of course I accept that, but what I do say is, and Mr. Justice Mann and this court relied on those cases as showing that distress wasn't distress or any other form of damage in the ordinary sense wasn't a necessary precondition for making an award of damages.
Right, but this is not binding on us anyway.
It's not binding, Lord, it isn't, and far be it for me to suggest, but it's interesting that both AAA and Weller both came to this court and other matters, and no, in neither case was any issue raised on either point. The fundamental point, why Mr. Justice Mann regards them as important, are there cases where awards of damages were made, as I say, in the absence of distress or any other form of damage in the ordinary sense. The awards obviously were made for the infringement of the right itself.
But Mr. Tomlinson, this is the central issue in this case, and in that case it appears to have been hardly argued. So we have to have a juridical basis to find that you're right. It's interesting to see that a judge has let it go through, but it's not necessarily important from the point of view of the legal argument that founds it.
Well, Lord, I'm coming to the juridical basis because that's a step, and that's a step in Mr. Justice Mann's analysis. He refers to those cases, and then if I could take the judgment up again, so we're back at authorities to tab 34. If I take it up again, he deals with a number of counter arguments advanced by Mr. Nicklin against the idea that you could have damages for the mere infringement of the right, for the loss of control, and which he rejects, and then 131. He's dealing with the Mosley decision, which I know the court will be familiar with, and cites a passage from Mr. Justice Eady in that case, the end of 131. But then 132. So he's concluded that damages for the infringement are appropriate. This conclusion is not to reintroduce vindicatory damages by the back door. So he deals directly with the issue which my lords have, the lady had mentioned already. What is still open is allowed to compensation, this is the top of page 350, to be given for the act of misuse itself where appropriate. I do not see in principle why that should not be allowed, and good reasons why it should be. One assumes for the moment each case is alleged to have happened had happened. The defendant will have helped itself over an extended period of time to large amounts of personal private information, treated its own to deal with as it thought fit. The infringement of the right which is sustained and serious, while not measurable in money terms, not necessarily a barter compensation. Damages to reflect the infringement are not vindicatory in the sense of lumber, they are truly compensatory. And then, and this is an important stage in the argument, and I accept, this is not, I anticipating a point from the court, this is not reasoned out in detail, but this is the decision of the Court of Human Rights in the Holford an United Kingdom case from 20 years ago. The court may recollect it was Alison Holford was a senior police officer whose telephone had been intercepted in relation to disciplinary proceedings, and she brought an Article 8 claim in the Court of Human Rights and succeeded. And the court there, so paragraph 133 of Mr Justice Mann, citing Holford, what the Court of Human Rights said, well, they weren't persuaded that she suffered any distress as a result of the interception of her telephone calls. However, they nevertheless awarded her £10,000 just and equitable compensation. Mr Justice Mann comments, since no additional distress was caused by the interception, it must follow that the award was for something other than distress, namely the intrusion into her private life. Now,
I appreciate, I don't think we got number in the bundle of authorities. I can understand that, it's a very long decision to photocopy, but I appreciate also the danger of labelling, but I'm slightly struggling with this notion that these are not vindicatory damages, as Mr Justice Mann simply says, because if you bear in mind the way Lord Dyson approached it in Lumber, you would have thought it was precisely within what Lord Dyson said you can't do.
well, it may be that the notion of vindicatory damages is, and we don't have the authorities, and we can get them if that would be helpful to the court. But the notion of vindicatory damages came from a speech, I think, in a Privy Council, the opinion in a Privy Council case by Lord Scott, where he said that you could have a special category of vindicatory damages for infringement of constitutional rights, and that was the argument that was being advanced in the Lumber case, that because your fundamental constitutional rights were being infringed, you should have a special category of damages to reflect that fact. And that was the argument that Lord Dyson considered and rejected.
But Lord Dyson also made comments about the implications for torts as well. And all the potential consequences if you had vindicatory damages for torts.
Well,
we perhaps maybe at some stage come back to that. But
well, we can certainly bring.
But it's set out, actually. What was that paragraph? What he said.
Yes, Mr. White helpfully reminds me that 127, Mr. Justice Mann deals directly with Lumber and cites the relevant passage from Lord Dyson's judgment.
So should we look at that?
Yes.
Paragraph 98.
So 98 is it's actually a House of Lords case, my mistake. Ashley and the Chief Constable of Sussex at the top of this is page 348. Lord Scott's so Lord Dyson is considering at 98 in Lumber the concept of accepting damages for violation of constitutional rights, referring to Lord Scott in Ashley and to Mosley, saying that it was endorsed to some extent in Mosley, and then, as he says, Lord Dyson goes on to rule against recovery.
yes, well, it's really what Lord Dyson said at 100 and 101 that I had in mind, particularly 101.
Yes. Far-reaching implications and so on, and no justification. Well, that approach was Mr. Justice Mann accepted that was the majority view of the court in London, at 128. Concludes that vindicatory damages are not what's being sought in this case.
I know that's what he says, but
Well-
just a matter of substance, I'm slightly, in a mist at the moment. Anyway,
I mean, what do you say about it? Do you say that was overturned?
No, what Lord Dyson said is overturned. No, I think I'd have to accept that. But that was analysed by Mr. Justice Mann and also by this court, and I'll come to that in a moment, because this very argument was run in this court when Gulati went on appeal.
Is it, if one goes back to paragraph 126 and one looks at what was said by Mr. Justice Eady in Moseley, also in 2008, these cases here come about the same time. If one looks at the middle of the paragraph 216, this is where he says, is this what you are saying in this case, different from vindication of reputation? It's simply to mark the fact that either the state or a relevant individual has taken away or undermined the right of another. It's a relevant factor, but the underlying policy is to ensure that an infringed right is met with an adequate
Yes.
remedy. That's really what you're saying here, isn't it?
Yes. Maybe if that's helpful. It's and the purpose of, I suppose the distinction would be, the purpose of vindicatory damages is simply to say, as against the state, you, the state, have done wrong to this individual. Here we're not talking about vindicatory damages against the state. We're talking about damages against a private body for breaching private rights, albeit ones which are reflective of fundamental rights in the Charter and the Convention.
but in the present case, can it not be said that let it be granted that in the ordinary way a right should be accompanied by a remedy by the right is infringed? In this case, Parliament has decided how to go about it by choosing the words of Section 13 as it has. And that's compatible with European law, because Parliament here has decided the circumstances in which damages will be paid.
Well, but I think that's circular as the sense as well. If damage means if non-trivial infringement of rights is a form of damage, as I say it is, then what I say is compatible with the wording of Section 13.
So you say it's not about causation, it's about the meaning of damage.
Yes, and the otherwise, otherwise what's been, and what the judge did was to in effect take a narrow construction of Section 13. When as my lady said, by reference to the paragraph from Mr. Justice Eady in Moseley, what's important is to in appropriate cases to provide compensation for the infringement of the relevant right.
May not be true, but why is Section 13 confined to individuals? What about corporations? Do they have no remedy?
Data protection rights are only inhere in living individuals. So the dead and non-natural persons have no rights whatever under the data protection legislation. That's an interesting question as to whether that's compatible with the way that Article 8 has been understood by the Court of Human Rights. But
It's probably an aside thought of mine.
That's very, very well established. When it comes to corporations, well, all I can say is the answer is that it's been decided to draw the line there. So the position is that if someone unlawfully processes my data, and as a result my children suffer terrible detriment, they can claim damages in principle. And there are some cases where, on obviously slightly unusual facts, where a data subject's infringement of their rights has caused damage to a third party. But if the damage was caused to a family company, the answer is no, there would be no claim.
Anyway, that's not this case.
And I suppose it might be said, well, the charters of rights are about, in general, the rights of natural persons, and so the position of non-natural persons is weaker and different. We said there's no doubt that Mr. Justice Mann directly addressed this point and directly found that such damages were recoverable. The case then, the case was then, as I said, went to this court. This is at tab 37 of the Authorities Bundle 2. And again, central to Lord Panic's argument on that appeal in favour of the Mirror Group's appeal, ground one of the appeal was that the judge was wrong on this point. The treatment of that begins at paragraph 39. Lord Panic for Mirror Group submits the judge was wrong to hold that damages were awarded for the mere intrusion into a person's privacy independently of the distress cause. The arguments that are advanced or addressed by Lady Justice Arden in that case, I should say in passing that something was made of Biddle Hall, both before Mr. Justice Mann and also in the Court of Appeal, but both said, well, this just wasn't an issue in Biddle Hall, so it can't really assist either way, because Biddle Hall was all about distress, and so nobody argued any point about whether there was a claim for infringement of the right itself.
But there are dicta in Biddle Hall which may be relevant, which we perhaps do need to look at. Do you say they support you or not?
Well, there are dicta in Biddle Hall which support me importantly on the question of whether the approach should be consistent under European law and under the Charter and under the Convention.
Yes, we can.
And I say that they certainly do support it. There are a number of references to distress, because the argument in Biddle Hall was entirely focused on the question of what the word damage, whether the word damage included non-material damage, and whether, and for those purposes, it was non-material damage was treated as being synonymous with distress. So whether it extended beyond distress wasn't an issue on the appeal at all. I think Mr. White will agree with me on that.
Well, you were both in it, and I was there.
It simply wasn't a matter that anybody considered in that case.
But you're taking us to Galati now.
Yes. So my Lord perhaps wants to.
Well, I mean, there's paragraph 81 of Biddle Hall that says that there's nothing in the language of Article 23 which indicates an intention to restrict the right to compensation to the former being, in many cases, the resultant damage will be an invasion of privacy which meets the threshold of seriousness required by Article 8. In some cases it will not. I mean, you've got to read the whole thing. But it does seem to me to be talking about non-material damage being, it not being intended to restrict
So I'm getting lost. Are we doing Galati or are we doing Biddle Hall?
We're certainly doing.
You were trying to do Galati, I think.
But my lord, I'm happy just to deal with the Galati, as it were. Just hold Galati for 1 minute at Biddle Hall. In Biddle Hall, the court was rejecting my argument at those paragraphs. So I was trying to argue that there was a problem about section 13.2, which on the face of it barred my claim because I didn't have damage, and in the sense of financial or physical or other heads of damage apart from distress. And one of my arguments, which the court rejected, was that damage could be construed as being damage for the purpose of interference with Article 8 rights, and that's what those paragraphs are about. But there was a lot of argument about what constituted, whether damage covered non-material damage as well. But what we didn't discuss was what the extent of non-material damage was. And my case in this court, if put shortly, is that non-material damage covers not just distress, but also damage constituted by the infringement of the right itself. If I can now go to Galati, so that's tab 37 in the authorities fund, and I drew attention to the ground 1, paragraph 39, where Lord Panic is directly attacking the finding of Mr. Justice Mann on this point, and the alternative submissions are considered, and then Lady Justice Arden summarises the position at 45. In my judgment, the second sentence, my judgment, the judge was to correct to conclude the power of the court to generate general damages is not limited to distress and could be exercised to compensate the claimant also for the misuse of their private information. And then she goes on to give examples and to say in terms the claimants are entitled to be compensated for that loss of controller's information as well as any distress. And then she goes on to rely at paragraph 46 on privacy being a fundamental right, and then distinguishing the Marion Ministry of Defence case about false imprisonment. And then at 48, I agree with Mr. Sherborne's submission on Biddle Hall. There was no claim in that case beyond damages for distress. I also accept his submission about vindicatory damages. Damages in consequence of a breach of a person's private rights are not the same as vindicatory damages to vindicate some constitutional right. In the present context, the damages are an award to compensate for loss or diminution of the right to control formal and private information and for the distress. So I accept, of course, Sir Geoffrey Voss's point that these issues weren't directly considered in cases such as Weller and AA, but they were directly considered in Galati. They were subject of direct challenge in this court, and the arguments were rejected. So the decision of this court in Galati is that in misuse of private information at least, you can have damages for loss of control or the interference with the right itself, and that these damages are not vindicatory damages in the sense disapproved of by the Supreme Court in London. And as we point out in our skeleton argument, the Supreme Court refused permission to appeal against that decision of this court in Galati. judge seeks to deal with that. Paragraph 71 of his judgment by saying, well, in effect, this is a special case, and Goulat is a special case, and should be confined to its facts, or should be confined to such an exceptional situation. He refers to Lady Justice's argument at paragraph 106 of Goulat, refers to the case as being exceptional, and the judge fastens onto that. Of course, it was exceptional, and the damages awards were very substantial, but the observation about exceptionality is not made in the context of the discussion of damages for loss of
It's in
control.
the context of quantum.
It's made under ground 4 of the appeal, where the complaint is that there's double counting, and as it were, evidence of double counting is the huge size of the awards, and Lady Justice Arden says, well, it's such an exceptional case that there's nothing in there.
Are you submitting that the reasoning and conclusion of the Court of Appeal in Goulat is binding on this court in the context of the Data Protection Act?
I couldn't go quite that far. I'm bound to accept that the Data Protection Act is different from the tort of misuse of private information. However, what I do say is that the two are so closely related that it would be inconsistent for this court to take a different approach to damages in the context of data protection from that taken in Goulat.
What you're really saying is they're branches of the same tree,
Yes.
which is the rights that are protected, private rights that are protected under the Charter.
Yes, and Mr. Justice Tugendhat always used to say that really we're talking here about Article 8 torts. We've got misuse of private information is an Article 8 tort, data protection is an Article 8 tort, harassment is an Article 8 tort. Can I just, I mentioned an observation in this court in Vidal Hall. Can I just turn it up because it's important? It's paragraph, it's tab 33, the authorities point. And paragraph 77 in the joint judgment is dealing here with the issue as to whether there should be compensation for distress. The remarks are of general application. Just between letters F and G. Furthermore, it is irrational to treat EU data protection law as permitting a more restrictive approach to the recovery of damages than is available under Article 8 of the Convention. It is irrational because, as we've seen above, and above paragraph 56 and 57 set out Article 1 of the directive, which says that its object is in particular to protect the right to privacy. It's irrational because, as we've seen, the object of the directive is to assure data processing systems protect and respect the fundamental rights and freedom of individuals, notably the right to privacy, recognised in Article 8 of the Convention and general principles of community law, to see recital 10. The enforcement of privacy rights has always permitted the recovery of non-pecuniary loss. So this court in Vidal Hall is emphasising that it's irrational.
Well, that was the section I had in mind, paragraph 78, it would be strange if that fundamental right could be breached with relative impunity by a data controller, save in those rare cases where the data subject had suffered pecuniary loss as a result of the breach. I agree that it could be construed as talking about distress, but
Well,
I think that's not what they were saying.
well, it's certainly talking about distress, but the question of what else they're talking about wasn't. Nothing else was an issue.
Yeah, okay.
So this court said, and we say correctly, that it's irrational to treat the two as being different. We're talking about, as the lady says, two branches of the same, coming from the same trunk, and the approach should be consistent. And that the judges attempt to distinguish Gulati was unsuccessful. Can I just deal with...
Just, are you saying that in some way section 13 is to be read down?
Well, I don't think I have to say that. If
said,
necessary, I would say
you said on a mile leasing approach to interpretation. You get that?
I don't say I have to say that, but if I had to say it, I would say it.
But you said with adopting the European approach,
Yeah,
having
well,
regard to the directive and the purpose, you get that?
Of course, yes. I understand that, but I say actually you could, if damage is construed in the way that it's construed in Gulati, you don't need to. But if necessary, yes.
Well, that's the point, isn't it? I mean, damage, you say, because we're looking at torts that have the same common origin, must be construed, or should be construed,
Yes.
in the same way in relation to the two situations. Otherwise, there would be inconsistency. Is there any authority that helps us on that kind of inconsistency?
Not that I'm aware of. But of course,
The judge said it was a very different situation.
yes.
I mean, the judge says that was a special case, a case of infringement of people's private rights to their telephones and their communications and so on. So he sort of, if you like, builds up that aspect of those cases and says this is quite different.
Yes, but the difficulty with that is that the discussion of the availability of such damages is not in any way confined to the specific facts of the case. It's not. It's a general analysis of the availability of such damages, which must apply in principle, whatever the nature of the wrong, whatever the nature of the infringement in the particular case. Google deals with this in its skeleton at paragraph 15. And makes 5 points in response. It's page 47 of the core bundle, tab 3. The first is they refer to the judge's paragraph 65 of the judgment, where the judge draws attention to the fact that in Gulati, Mr. Justice Mann, when Biddle Hall was referred to, said this is a case concerned with a specific drafting of the DPA and what's provided by way of compensatable loss. That's correct. Middle Hall was about the app, but it doesn't assist Google because Mr. Justice Mann wasn't being asked to consider what the proper scope of Section 13 was, and the Court of Appeal wasn't being asked to consider this issue. The Court of Appeal in Gulati made it clear that a passage I've already taken the court to, that Middle Hall was irrelevant because it was only a claim for damages for distress. This submission by Google simply doesn't deal with the point that I'm making, that the two must be approached in the same way because of the very close relationship between the two torts. Secondly, they say damage must be given an autonomous meaning because it's Article 13 was intended, Section 13 was intended to give effect to the directive, and the concept of damage is a uniform, autonomous European concept. Well, that's right. I don't disagree. We don't disagree with that. But Gulati is not simply a decision about national law, because Article 8 is the very content of the tort of misuse of private information. It's a tort which was brought into existence by a mysterious process that's quite difficult to understand, but by absorbing Article 8 into domestic law. So when damage is being considered in the context of Article 8, it's a European context as well. There's a consistency across European law between the Convention and the Charter.
Well, I wondered about that, Mr. Tomlinson. I mean, if it's a European context, I mean, most of the authorities tell us that damage is a municipal matter, is a domestic matter, where you have a breach of a European law right. The question of how it shall be compensated is a question of domestic law.
Well, the question of the quantum of compensation is certainly a matter.
Well,
of
quantum
domestic law.
certainly.
But whether compensation is available is a matter of European law. You can't. Indeed, the Leitner case, which was relied on in Middle Hall and was we say wrongly relied on by the judge, is precisely such a case where in domestic law they tried to confine. I think it was under the package holiday regulations, they tried to confine damage to material damage, and the Court of Justice said no, you can't. The concept of damage is a European concept. What this court and Mr. Justice Mann were trying to do, stripped of the, as it were, the domestic context, is that they were trying to interpret how compensation for Article 8 infringements work. And that's why the European authorities are referred to. So to seek to dismiss Gulati as well as being a domestic matter and therefore not relevant to this is, we say, misconceived. The third point I've already dealt with is the question of Gulati being exceptional. Fourthly, they say, well, things are different because the tort of misuse of private information has built-in safeguards in respect of minor interferences, whereas on our approach there are no such safeguards. Well, we say that that's wrong for these reasons. The way the tort of misuse of private information works is by first of all looking whether there's a reasonable expectation of privacy, and then balancing privacy against expression, Article 8 against Article 10. In this context, the second part is irrelevant. We're not talking here about Google's freedom of expression. If we were, freedom of expression is dealt with in the context of data protection in a different way from the way it's dealt with in the context of Article 8. It's dealt with by having journalistic exceptions, but similar balancing exercises in the end. But to get over the first hurdle in the tort of misuse of private information, the interference has got to achieve a certain level of seriousness, the point that Google makes. Well, we say, likewise, to attract compensation of the kind we're talking about, the infringement must reach a certain level of seriousness. It must be non-trivial. So in other words, on analysis, the positions are identical.
Does that come from European law, the trivialness threshold?
In which context?
Well, I mean, initially in the context of misuse of private information.
Well, in the context of misuse of private information, not quite right, but put crudely, Article 8 must be engaged before you get through the door into the tort. And the European law, I hesitate because I once argued in this court that if there was an interference with Article 8, you were through the door. And the court said, no, it's more complicated than that. But crudely, that's the position. Under European convention law, yes, there has to be a certain level of seriousness before Article 8 is engaged. Because the situations are analogous, that Article 8 is sometimes said to be an imperialistic article. It really covers the whole of human life if you're not careful. And to stop that happening, you have to have a threshold of seriousness.
Well, should we not be showing some authority for that? Because if you're saying that the trivialness point is answered by the fact that both will need to apply the same European law standards, the same concepts, then we probably need to see why it is a matter of European law that that you have to overcome a trivialness threshold to get through the door to make good that point, if you're right, because it's said against you that there is a difference between the two, and that there is no de minimis threshold under DPA under the statute.
Well, I don't believe it to be controversial that there's a threshold in relation to Article 8. In relation,
That's not controversial. It was said by Lord Walker in M and the Secretary of State, and it's been repeatedly said in this school.
yes, and in Strasbourg as well. It's in relation
It
to.
would help me, I'm afraid. I'm not as familiar with this part of the case as others. It would help me to see the authority.
Yes, well, we can certainly get it out. In relation to section 13, there's much less in the way of authority, because it was only after Viddle Hall that effectively damages claims became available.
Sorry to interrupt you, but just you say that a certain level of seriousness must be involved.
Yes.
Seriousness as to what?
As to the breach.
The infringement itself,
Yes.
not as the consequence.
Yeah, yes, as to the breach. Yes.
But supposing a breach is entirely trivial, is entirely inadvertent and one-off, but as it happens causes immense consequences. What then?
Well, in assessing the seriousness of the breach, well, obviously we'll also have to look at the consequences.
You have to.
Yes. I would say. But as this,
Right?
maybe in relation to my Lord's point, the matter has not been particularly, because as I say, because only post Biddle Hall were these claims available. There's reference in the first instance decision in TLT, which is at tab 35 of volume 2. That's in relation to paragraph 15, a de minimis threshold in relation to distress. That's as far as one gets in the authorities. When TLT came to this court, a bit like Weller and AAA, none of those points were an issue, and so the judgment of this court says nothing about the position. But well, I'm not. We'll certainly see whether there's anything else that helps. But my point is this: that a consistent approach needs to be taken in relation to the data protection and the misuse of private information cases, and that consistency is achieved by, as it were, mirroring the threshold of seriousness in both cases. You can't say, well, a trivial interference with Article 8 doesn't attract damages, but a trivial data protection breach does attract damages. That would be inconsistent. And similar the other way around. And the other way around was the position in Biddle Hall, if you like, that wasn't quite how Mr. White was putting it, but it was being said, well, it doesn't really matter how serious the breach is of your data protection rights. It doesn't attract any compensation because you suffer no loss.
I mean, in normal torts, it's obviously clear that damage is an essential element of the tort. And so when you say that in order to determine seriousness, you have to look at both the infringement and the damage, I mean, that submission that you made rather jarred with me, because normally when you look at a breach, you look at the breach rather than the loss that arises from it. But do you place any reliance on
Lord,
on
it's a
that?
long time since we've debated the question of torts actionable per se and actions on the case.
Yes.
The position is, in some torts, damage is of the essence of the tort. Negligence, malicious falsehood,
Yes,
malicious prosecution.
but not these.
In some torts, damage is not the essence of the tort. Of course, the most well-known until recently, until the 1st of January 2014, was libel, where damage was not the essence of the tort. Things have changed. But trespass, false imprisonment, torts such as that, the damage is not the essence of the tort. And there's no doubt that misuse of private information is a tort actionable per se.
Right.
Because
That's my question.
in contrast to negligence, as my lady and my lords know, in a negligence case, the defendant can be as negligent as can be. If they don't cause any damage, there's no cause of action, however upset the claimant is. You need that tiny bit of damage to get the tort constituted. Whereas in false imprisonment, I think Mr. Wilkes was falsely imprisoned in the 18th century and given beer and beefsteaks and was very happy, but nevertheless had a claim for substantial damages because his right had been interfered with and damage wasn't the gist of the cause of action. So, my lord, Your Lordship says a
So
normal...
then pushing that forward, you submit that when you consider the seriousness of the breach, you look at both infringement and the damage it causes in answer to my lord.
Yes.
How does that work?
Well, we're dealing here with the effective protection of fundamental rights, and so that's what misuse of private information and what data protection is about. And in that context, one takes a, as it were, a practical and effective approach, and one says, well, is this serious? Is there a serious interference with the right? Is there a serious breach? And one looks at both elements, I would say.
Just from my note, Mr. Tomlinson, you said in misuse of private information cases it is actionable per se.
Yes.
Is the authority for that?
Well, these arcane categories are not much discussed in the case law, but it's necessarily the case because you can recover some mere distress. So damage is not, you don't, to establish the tort, you don't have to prove damage.
It is their authority for that proposition. I mean, I'm not saying you're
No,
wrong, it's just I quite like to know the authority for it.
Virtually every single misuse of private information case involves only distress and not...
But that's damage. That's damage.
No, my lord, it isn't. For the purposes of the distinction between the two torts, it's two types of tort. It's not. That's why, as I say, a negligence claim where only distress is proved and no damage, or the classic the discussion is in the context of malicious prosecution. If someone is prosecuted and they don't suffer any financial loss, they're not imprisoned, they're not suffer physical harm, and the charge is not one that's defamatory, there is no case.
Yeah, I understand.
Even if they're distressed as can be.
Now, I understand. I understand the conceptual difference entirely.
Absolutely.
And torts do have different statuses in that context. But all I just is wanting to know, because
I could get out.
Is there an authority which, in terms, says misuse of private information is actionable per se?
I suspect not. But I'll try and look it out.
I'm not trying to say you're wrong. I guess it would just be quite nice.
But my lord, but the reason I say that is because that it is not necessary to prove damage in the classic sense of one of the classic heads of damage being economic damage, damage to property, damage to life and limb, or possibly damage to reputation.
Would you call that material loss?
Yes, that certainly is what we, I think, when discussing the issues in Biddle Hall, we treated that as material loss and non-material loss being distress, with reputation being a bit unclear.
Right, so I may have misread Biddle Hall as using non-material loss to mean something more than distress, but really you say that was a cipher for distress and that kind of damage.
Yes, I hope the lady agrees with me, but my understanding of
judgment, so she'll no doubt be able to tell us.
the way that the argument was run in because the scheme of the statute distinguished between damage and distress. Section the now defunct section 13.2 said you could only recover distress if you prove damage. So therefore, damage one can see it in the bundle. An individual who suffers distress by reason of contravention of any of the requirements, etc., is entitled to compensation of distress if the individual also suffers damage. So damage meant damage other than distress, and that's why ultimately that section was struck down. That subsection was struck down by this court because as being contrary to the right to an effective remedy. I accept and think everyone knows that there's very little discussion of these issues on the authorities, because there's in relation to data protection, as I say, until Vidal Hall, because you had to prove damages claims were very, very rare. Perhaps I could just take you to one case which illustrates how the court sought to get round that, and is perhaps of some interest. It's a case of Holiday and the Creation Consumer Finance. It's at tab 29 of the volume 2. And that was a case involving a data protection breach relating to a consumer credit agreement. And the position was that, I think, unless the court wishes it, I don't propose to read the head note, but the issue in that case was whether the judge had held that because there was no damage, there were no damages. And the matter was considered by this court, and perhaps I could take it up at paragraph 35. Lady Justice Arden notes there was no contemporary evidence of any manifestation of injury to feelings and distress. And then she notes that it's important to mark violations of this kind where there's been frustration with some kind of remedy. And then says at the end of the paragraph, I would accept as a general principle where an important European instrument such as data protection has not been complied with, there ought to be an award. It's expected that the complainant will be frustrated. And so what's then done in that case is that the court treats the award of nominal damages for the breach of the data protection rights as being damage, and so seeks to get round section 13.2 in that way. If one looks at paragraph 42 at Lord Justice Lloyd, I agree with Lady Justice Arden, the appropriate consequence of finding a contravention of the Act, but no identifiable financial loss, the award of nominal damages in the sum of £1, and then as a result of a concession, it opens the way to assessment for damages for distress. So what we take from that, it was a pre-Gulati case, and no argument was addressed on user damages or damages for loss of control. But and the point about using nominal damages as a platform for distress damages went by concession and is not relevant. But what we say is important is the recognition by this court that when a fundamental right is under a European instrument such as data protection right is breached, there ought to be an award.
Did the judge refer to it?
I'm sorry?
Did the judge refer to it?
Did the judge refer to
Howard, they referred to Howard.
Yeah.
It certainly was cited.
72 line.
Okay.
Oh.
he simply says it doesn't assist because there's no claim for damages for distress, but missing the point that I was seeking to emphasise, that this is a case where it was accepted by everybody that there was no damage, as in the sense then required by the section, but nevertheless, Lady Justice Arden says as a matter of general principle, where important European instrument has not been complied with, there ought to be an award.
Quite a surprising conclusion in Halliday that you can find as a fact that to some extent your financial reputation is damaged, but you only get £1 for it. A surprising conclusion, however. Fact specific, no doubt.
Well, also that there's a history because the this court in a case called Johnson and the Medical Defence Unit closed off all those kind of arguments in relation to Section 13. So
that's the case that was discussed at some length in Riddle Hall.
Indeed, it was. So people had tried before Riddle Hall to get round Section 13(2) by various means. The entertaining thing about Mr. Johnson was he claimed his financial loss was that he bought himself a second breakfast at the hotel where he was staying, and that cost him £2.50. So that was the financial loss which gave rise to an entitlement to damages for distress. His case failed.
I think Mr. Halliday was a bit more meritorious than that.
Mr. Halliday may have been a bit more meritorious. But
all right.
Anyway. My lady, my lords, it's not a. It's an observation which I obviously rely on for what it's worth, but it is, we say, an important one. The judge fell into, we say, plain error when paragraph 61 of his judgment where he expresses the view that non-material damage for the purposes of European law must be genuinely quantifiable damage, referring to a case which I have already mentioned in passing, a case called Leitner and T.I.U. Deutschland, which is to be found at tab 42, Authorities Volume 2. What he relied on there, that expression, he describes it as AG 38, or rather A38, at page 100 of the judgment, page 100 of the report. And the Advocate General in that case says the Court of First Instance recognised that such liability extends to non-material damage provided genuinely quantifiable damages occur. It's a curious phrase because it's difficult to understand what genuinely quantifiable could mean in the case of non-material damage. It's difficult to know how distress is, for example, is genuinely quantifiable. But this is a phrase which, this is the Advocate General, and when the court deal with the matter, that phrase is not replicated. One finds the court's, the substance of the court's decision on page 108, paragraphs 23 and 24. the directive implicitly recognises the right to compensation for damage other than personal injury, including non-material damage. The answer must therefore be that Article 5 is interpreted as conferring in principle on consumers a right to compensation for non-material damage. But the concept of it being genuinely quantifiable, which the judge relies on, doesn't feature in the judgment, and as far as we're aware, doesn't feature anywhere else in the European case law. And the judge was led into error by relying on that comment from the Advocate General into suggesting that there was some kind of threshold of genuine quantifiability before damages could be awarded. And therefore, he to the view that you need at least distress under Section 13 to recover damages, which is, as I've said, inconsistent with the approach of the Court of Human Rights, for example, Holford. And inconsistent with the approach of this court and this Justice Manning Gulati. The point which is taken against, we say, bad, is that somehow we're seeking to do what the rather desperate Claimant in Shaw and Kovac was doing, namely to create some kind of conventional award for loss of autonomy. Letting, in Lord Dyson's word, I wanted to use this phrase, an unruly horse loose in the law. That's not what we're seeking to do.
Well, what's the essential difference between what you're seeking to do and that concept?
What we're seeking to do is where there is a breach of duty owed under statute as a result of European legislation, we're saying that the victims of that breach should be compensated for the loss of their rights. That's not in Shaw and Kovac's. What was, well, there were many arguments being advanced, but the one under this head appears to have been that in the tort of negligence, the court ought to recognise a new creature, damages for loss of personal autonomy.
But I mean, you're saying, aren't you, that you should get an equal amount for every claimant?
Yes, but that depends on the assessment of the court as to the nature and quality of the breach. We're not saying that, as used to be the position of common law prior to the Administration of Justice Act, whatever year it was, 1982, thank you, that there's a conventional award which should be made in every case, whatever the facts. We're saying this is an award which depends on the facts. I mean, let's...
But I mean, I'm sorry to press this, but you're saying it depends on the facts, but not on the facts of the reaction or anything else of the claimant, individual claimant.
Correct. We're saying it depends on the facts of the nature of the breach.
Which comes back to whether the breach includes the loss, which you said has to be looked at in order to determine whether it's non-trivial.
Yes.
I mean,
the
what
fact-
at the
the
moment
fact-
I don't understand is the essential, and I use the word again, juridical difference between a conventional award and that kind of award, where you don't look at the loss suffered by the individual claimant in order to evaluate how much it is.
Well, a conventional award, as I understand it, conventionally means you pick a sum, £10,000 or whatever the figure is for loss of expectation of life, under laid down by statute, and that same sum is awarded in every case, whatever happens. Here, I accept that if Google establishes that on analysis these breaches were entirely inadvertent, utterly trivial, and of no significance, then no award should be made. I mean it's not a situation where I say, well, in every case the same sum should be awarded.
I'm not sure I quite understand this. You've disclaimed punitive and exemplary damages.
Yes.
So once it's like the negligence, gross negligence. So what? It makes no difference to the terms of the damage you recover. It's just an epithet. So I'm not quite following why the level of what they've done impacts upon the compensation to be awarded. The grossness of the breach is irrelevant on that, isn't it?
Well, we say it is, and we say it is because in terms of the impact on your right, the nature of the breach that they engaged in is something which changes the value of the right to you. And that may or may not be a good argument. I'm not at this stage. We're not in the territory of analysing the quality of the breach and how that impacts on the level of damages. But we're at the stage of having permission to serve out of the jurisdiction
When
to
you
the earliest possible
when you say
stage.
the value of the right, you're not talking in terms of financial value here, are
Well,
you?
that I have an alternative argument about that.
No,
which
but
I'll
at this
come to
stage of the
shortly.
argument. At this stage of the argument.
No, it's exactly as in Gulati. It's the value of the right to the right holder.
And you say the grossness of the breach has a bearing on
Yes.
that.
Can you put that in concrete terms and give us an example of what might be relevant in that context?
Well, if the position is that I'm using a Google service and Google inadvertently breaches the requirements of the data protection legislation, so processes in my data in a way which is on analysis wrong. The position is that I would say, well, if that's a trivial breach, what's the loss to me of my autonomy? What's the loss of my control? It's something which is de minimis and not worthy of compensation. On the other hand, if Google systematically sets about deciding to use my data obtain my data, use it for commercial purposes, in cynical disregard for the relevant provisions, knowing it's doing wrong but deciding that it's unlikely to be discovered, so it will do it anyway, that is a grosser invasion of my right than the first.
But supposing I'm completely oblivious of the fact that they're doing it.
Well, as with the children in AA and Weller, they're completely oblivious of the fact that their rights have been invaded. But nevertheless, as Mrs. Holford had in terms of her interference with her telephone communications, she was completely oblivious that it had happened. It made no difference to her. Nevertheless, I'm entitled to compensation, I would say.
Well, speaking for myself, it would be a matter of great concern if, and I say if because people could behave, and data controllers could behave in the example you have put forward and suffer no sanction. that would be a matter of great concern.
Yes, and that's the
But
practicality.
what might be said is the grosser the breach, the more the regulator authorities will be crawling all over those people and imposing really heavy fines.
Well, with respect, we say that the question of the regulatory authorities is irrelevant to these kind of cases, because the regulator has got a huge amount of things to do and limited resources. The regulator, it is true that in this case it so happens the UK regulator has done nothing. The US regulators have fined Google large sums of money, but the fact the remedy available to individual citizens can't depend on whether the regulator has got the funds to or the resources to investigate a particular matter. The fact that there's a potential regulatory sanction can't mean that therefore no effective remedy for breach of individual rights is required.
Well, if that was the position, I suppose you might be putting forward an argument under Article 22, relating to Article 22 of the directive.
Article 22
I think it's Article 22, isn't it?
deals...
Well, that was a question of the providing a judicial remedy.
Yes, so that's a judicial remedy which is not not compensation, and I think it appears that Google may accept that in theory that other remedies would be available but not compensation. The practicality, and forgive me for making this jury prop, but the practicality is, if this kind of action is not available, no action is available, because it's obviously not commercially viable for individuals to bring cases, and to constitute a GLO is costly and administratively difficult, and when the damages are likely to be small, as they are in a case of this sort, it's simply not commercially viable. So if this kind of action won't work, nothing will work. Now, I think Mr. Justice Warby's answer to that, if I could, my understanding of his answer to that is twofold. Firstly, well, the regulator can take whatever action the regulator wants to take, and if Parliament wants to change the law to provide a remedy, Parliament can change the law, but without that we've got nothing. And I say that looking at the Galati approach to damages, and I'll come on some stage later today on the representative action procedure, the two taken together are capable of providing an effective remedy.
Just picking up on what Sir Geoffrey Voss put to you, on your approach, the effective remedy is uniform for all of the
Yes.
representative group.
Yes.
And I'm still not then quite clear, why is that not a conventional award?
Well, no, that's a question of labelling in the end. It's
Well,
not a convention.
you denied it was a conventional
Yes.
award, and so would you tell me why?
Well, as I said before, I understand a conventional award to mean you get the same sum of money, whatever happens, whatever the nature of the breach. So whenever if you're a dependent and the person on whom you depend dies as a result of someone's negligence, you always get the same amount of money for your conventional bereavement award. It's not tailored to the facts of the case.
Well, the facts could include the length of the period over which the breach occurred, for example.
Yes.
You would say.
Yes, for example. So the conventional award that's referred to in Shaw and Kovac, the award for the wrongful birth cases, the anomalous case, that's the same sum. It's the same sum in all cases. It's a conventional sum. we can't assess this on a case-by-case basis, so we'll give you the same sum in each case. That's not what I'm asking for. Now I accept, and this is perhaps an important point which I haven't addressed, some people in this class will have suffered specific distress. For example, the 3 claimants in Little Hall, who stretching my lady's memory very far now, but in Vidal Hall there was evidence that they gave that specifically about the effect that it had on...
I remember it very well, and some of it was in confidential schedules.
Yes, quite so. Now, so there will be individuals who've suffered distress out of this 4.4 million who will, in one sense, be being undercompensated because they won't be compensated for their individualised distress. Well, that's hardly a complaint that lies in Google's mouth, but the position of those individuals is that, for obvious practical reasons, they've chosen not to bring their own cases. They're in fact it's now too late because they'll be out of time. But the fact that there's some individuals may be undercompensated is not enough. If we were in time and there was a representative action, they could have opted out. They could have chosen not to be part of the representative class. So the potential problem of undercompensation can be avoided. But it's we say a conventional sum is appropriate, and a conventional sum is appropriate because of the authorities I've referred to a number of times, and also that works for the purposes of representative action. Can I now come on to root and part damages, which is my alternative way of putting the case?
I mean, if you're right, you don't need them.
If I'm right, I don't need them.
Yeah.
But if I'm wrong, I do need them. I referred already to the way we plead it in the particulars of claim, paragraph 42. The sum that they could reasonably have required for to be compensated for what they reasonably could have charged for releasing the defendant from its duties. This is again a uniform per capita sum.
Were root and part damages considered in Gulati?
No. I'm saying no, but the team will check. The judge deals with it, paragraph 76 onwards. And he begins by saying, well, this is contrary to the decision of Mr. Justice Patton in Murray and Express newspapers. It's perhaps worth just turning that up. It's in Authorities Bundle 1, tab 21. I say immediately that is indeed what the judge held indeed what Mr. Justice Patton held in Murray and Express newspapers at first instance. It's at paragraphs 90 to 92, and the issue was raised in that case precisely because this was if I can put it this way, a proto-Weller case. In other words, it was the same kind of point that was ultimately decided in Weller. It was the photographing by paparazzi photographers of a young child who obviously couldn't suffer distress and hadn't suffered damage. To meet the point, as the judge says at paragraph 90, Mr. Spearman, who was for the claimant, contends I should award the claimant by way of compensation a sum calculated by reference to the market value of the data that's being misused. A reference to Ruton Park and Attorney General and Blake. And then 92, Mr. Justice Patton says no application because depends on analogy of property rights and so on. So that was, he certainly did dismiss that claim. We make 2 points in response to it. The first is that that case came to this court, and that's the next tab in the authorities part. And the judge had dismissed the data protection claim, and this court said, and the misuse of private information claims, as the position was that this court said no, everything should go to trial. So the appeal was allowed, and so the Court of Appeal doesn't specifically deal with that analysis, but it says at paragraph, Sir Anthony Clark, I believe, says at paragraph 63, issues under the Data Protection Act should be revisited by the trial judge. And a number of issues of some importance, including the meaning of damage. At least arguable the judge has construed damage too narrowly.
Well, that actually is disapproval, isn't it?
Yes, we would say. Because, well, it's not. There's no analysis, but his disapproval will go back to trial, and the case was ultimately settled.
You say Mr. Justice Warby's reliance on Mr. Justice Patton ought to be read in the light of the note of scepticism introduced by the Court of Appeal.
Yes. Well, it's slightly more than scepticism. The data protection claim was struck out, and it was reinstated by the Court of Appeal, who said he'd taken too narrow a view. And that these matters should be revisited at first instance.
I mean, it's ratio actually, because the decision was to overrule the striking out and to send the question of data protection damages back to be decided at first instance. And you tell us it wasn't ever decided.
Yes. So it's not binding authority. But in any event, the position in relation to Ruton Park damages has moved on, and in particular, there's the point which impressed Mr. Justice Patton, and indeed impressed Mr. Justice Warby in this case at paragraph 77, which is the point that the fictional negotiation is unreal in a privacy case. The paragraph 77 that the judge refers to the well-known discussion of that point by this court in Douglas and Hello. But of course it's unreal. Of course the position is that particularly in a privacy case, but not just in a privacy case, no one is really wanting to negotiate the giving away of a right that they want to protect. But the answer to that, we say, is to be found in the decision of the Supreme Court in the Morris Garner and One-Step case, where after reviewing the authorities in some detail, the Morris Garner is at tab 40, bundle 2 of the authorities.
Which paragraph?
Paragraph 91. And Lord Reid makes the point. We say obviously correct that at the end of that paragraph, just above letter F, the imaginary negotiation is merely a tool for arriving at value. So it's not that anybody thinks really there could be such a negotiation. It's simply a way of arriving at the value that can be ascribed to a particular lost right.
Although there is a debate now about monetising data and the ability of individuals to do it, so it's not very far removed from what might occur on the fact.
Yes. Well, that's exactly what we say. And to give just one example, it's not very far from this case, but as I'm sure the court knows, there are a whole series of online services where now you have a choice. You can have it free with adverts, or you can pay to have no adverts, and that's a value being set by Spotify or whoever it is on the adverts that they can otherwise feed to you. So the negotiation, I'm dealing here just with Mr. Justice Patton in Marriott first instance. The argument which impressed him and impresses the judge at paragraph 77 is one which is of limited or no significance. It's the argument about the unreality of the negotiation. Once one realises it's simply a conceptual device for helping in assessment, then that argument falls away.
But is data to be treated as a valuable asset?
Well, the one thing that comes out of the one-step case we say is that the root and park damages, user damages, negotiated damages are not limited to pure property rights. What one sees at paragraph 92, Lord Reid goes on to talk about cases concerning restrictive covenants, intellectual property agreements, or confidentiality agreements. Now, it's very well established. Confidentiality is not a form of property in the ordinary sense. It may be a form of quasi-property with some property-like features, but it's not. It's not a form of property which, in the strict sense. Lord Reid refers 93. I identifiable loss equivalent to the economic value of the right considered as an asset, even in the absence of pecuniary losses measurable in the ordinary way. That's something which is true of some contractual rights, the right to control use of land property or confidential information. And confidential information is a good example of an area where you may have you can't trade it on the open market. Many forms of confidential information can't be traded on the open market, but clearly have a value, and the tool of imaginary negotiation is a valuable one for working that out. Now we would say that data rights are closely analogous. The data rights are not property rights in the conventional sense, but they're rights which certainly have a value. I mean, the largest businesses in the world, indeed including Google, Facebook, Microsoft and so on, are businesses founded on exploiting the value of personal data. And as I said, there are now clear examples of cases where one has a choice of adverts or no adverts, and a monetary cost is put to it. We say that hypothetical negotiation could take place in this case, or could have, that tool could be used in this case. This is a case in which, using Lord Reed's words from paragraph 92, the defendant has taken something for nothing, which the claimant was entitled to require payment. So the one approach to assessing the value of damages is to look at effectively, if Google had been completely upfront about this, well, you can either operate on these terms where you have adverts, or these terms where you don't. What the monetary value of that would have been. But Google's business model depends on the selling of data. It itself puts a monetary value on the ability to target adverts. So what this is all about. It must be possible to carry out an imaginary negotiation to assess the value of that to this class of claimants. So if we're wrong about the Gulati basis for damages, if the court takes the view that doesn't work in the context of section 13, or that it's a conventional award, contrary to my submissions earlier, we can achieve a similar result by looking here at the imaginary negotiation and root and part damages, which, as the Supreme Court tells us in one step, is not a form of restitutionary damages, it's a form of compensatory damages where you're using this as a tool to assess compensation. We certainly can't, it's wrong of the judge, we say, to rule this out at the beginning of the action before we know anything about what's going on.
So that is regarding data as a valuable asset?
Yes. Which, Lord, I would say, plainly, beyond argument, it is.
Well, it's not property, according to Data Team.
It's not property.
No, but it is, you say, a non-rivalrous asset. In other words, an asset which you can you can get money in return for without devaluing the asset itself.
Yes.
Yeah.
I'm almost at the end of this section of my submission, which I will finish by 1 o'clock. Is that,
We have to rise promptly at 1 o'clock.
I will try to, the only other point I make is the question that was added by amendment to the grounds of appeal, which was that the judge, insofar as this is a difficult issue in a developing area of law, the judge shouldn't have determined it, but should have, in accordance with the general rule. I don't think it's necessary for the court to turn it up, but it's a well-known proposition in the Altimo Holdings case, tab 27 of Authorities Bundle 1, paragraph 84, where Lord Collins says the general rule is that summary procedure is not usually appropriate to decide a controversial area in a developing area, particularly because it's desirable the facts should be found. Now,
Isn't this a case where preeminently, since you really say that the facts are not going to be relevant save as to the scale of the breach, if it didn't matter what the scale of the breach was, and if you couldn't prove any loss, and you don't say that you have to look at the particular circumstances of the claimant, this court can determine it without fact finding.
well, the court can determine it, but the question is whether it's desirable to do so at the outset of the action. The way that Lord Collins puts it is that if the area is developing, particularly where the facts are relevant, but this is an area where we would say it's clear from looking at the authorities we've looked at this morning that the law is not settled, and the fact that this is in reference to a statute which has now been repealed doesn't actually change the position, because the same issues arise under the current statute and under the GDPR.
What's the section of the current statute?
It's the current under the current. It's
And
It's actually
the GDPR.
Article 82 of the GDPR, so
It's 168, my lord, it's tab 5 of the authorities bundle, has a short text out from 28 to 9.
Thank you.
yes, that's simply the point I was making is that it simply refers back to Article 82 of the GDPR, making it clear that non-material damage includes distress.
You invited the judge not to decide the point, did you?
Well, the position is that I can give you the bundle references, but I said on I think 5 occasions that this was a developing area of law where it should be left to trial. The Google cites one example where it looks like I'm agreeing with the judge that it's not, but I can, if necessary, I can take the court to a number of examples where I repeatedly emphasised this point to the judge that it was a developing
You were
area
not
of law.
conceding that he should decide.
I certainly was not. So, Lady and my Lords, summarising, this is on the first round, and I'm now at the end.
Well, if you're right on that, then our judgments can be very short, can't they?
Well, my Lord, no, because I'm
I was thinking of the way the Court of Appeal dealt with it in Murray, but no, go right. We're all here. Let's get on with it.
the representative action procedure is a big, interesting and
Yeah.
rarely explored issue, which I've got to come to this afternoon. But what I just say to summarise the position on the first ground is that there's no principal basis for distinguishing the approach to damages under the Data Protection Act from that under the tort of misuse of private information. But both cover the same areas, the fundamental rights, privacy rights of individuals and data protection rights. A point which I've not made before may or may not be familiar to the court, but the Court of Human Rights treats data protection as being a facet of Article 8. There isn't a convention version of Article 8 of the Charter, an express right to data
I think we
protection.
dealt with that in Stunt, actually. Then you see that arose and stuff.
Yes, yes. There are a whole host of cases where the Court of Human Rights deals with data protection issues, always under the heading of Article 8. And in practice, the cases show that very often these issues are argued together. TLT, which I mentioned in passing, was a case where the judge didn't bother to distinguish between the award for damages under the Data Protection Act and the award under misuse of private information. Similarly in wealth, again, the two were just, because usually if there's a breach of one, there's a breach of the other. And it would be wholly wrong, we say, and irrational to distinguish the two. So the judge should have followed the approach of the court in collating and held that the claimants and the members of the class were in principle entitled to recover damages for the infringement of their data protection rights without proving distress or some other form of damage. My lady and my lords, that's what I have to say on the first. I didn't mean to time it in this way.
Thank you very much.
Perhaps I should claim that I did.
We'll sit again at 2 o'clock.
So I think